Okay everyone, so let us start for today's lecture, right? Now if you look at the today's lecture, I have given you, I will be discussing two topics in law optional, right? The topic number 10 and 11, that is then the schedule of that particular topic, right? First is the election commission, their power and function, that is given in your law optional syllabus, and the second topic is emergency provision amendment to the constitution, right? Now I will go into nitty gritty that what you have to study in these topic in detail, okay? So obviously those topics simply mentioned, but obviously that is not the case here. You have to go into much detail, okay? So what you have to study, let us see. See, first you will be starting with the concept of election commission, only the bare constitutional provision, right? Now remember, most of the time people get confused that the election commission of India is somehow controlling the election commission of a state. That is a wrong statement. Election commission of a state is an independent body than the election commission of India, okay? So that bare provision with respect to the election commission of state and the election commission of India has to be studied, right? Now if you will read the bare provision, one thing you will notice, there are three type of election commissioner basically. One is the chief, another is the election commissioner, and then there is a regional election commissioner, RDC. Now RDC also wields so much power, okay? So go into the nitty gritty of the articles, right? 324, 325, whatever, right? And read that article in very much detail, okay? Do not only rely on Lakshmikant and and you can feel like the law optional syllabus will be completed. No, not at all, right? Go to the constitutional provision and read at least once the whole article, okay? Then you come to the philosophical aspect of the functioning of election commission, right? How it have historically performed, right? What has its been constitutional mandate, right? And does it have done a wonderful job since independence, right? Because you can also add with the especially with respect to GS paper 2, criminalization of politics, okay? So can election commissioner, or does election commissioner have controlled it in a good way, right? So those philosophical aspect with related to the working and the functioning of the election commission has to be handled, okay? Has to be studied, okay? So that thing you have to keep in mind, right? So vis-a-vis democracy you have to understand, or you have to in depth analyze, right? So reading 2-3 good articles related to it will suffice, okay? So that is how you have to study the election commission, because the question, mostly the philosophical aspect is this itself, right? Analyze the working of election commission since independence. Yeah, election commissioner through its constitutional machinery have it been able to check criminalization of politics, okay? So those sort of structure you have to understand, and right, and especially go to the power part, right? Power of election commission, right? Multiple case laws in which the court have sort of interpreted the power of election commission in such a manner that it is sort of a sea of power, right? Okay, so anything which is done in the pursuance of the conduct of election comes within the meaning of power, and the Supreme Court in multiple judgment have actually confirmed it, okay? That the nature is not illustrative but not exhaustive, but simply an illustrative in nature, right? Meaning the power authority, that is illustrative in nature, right? So anything that has to be done for the conduct of election, anything practically, okay? So that is not exhaustive, that anything can be defined, anything can be anything, okay? So that is the nature of power, broadness of the power, the omnipresence of the power of election commission, right? So that aspect has to be handled, right? And how that aspect, that particular nature of power have been used by the election commission till date, okay? So that particular part of the syllabus has to be focused, right? There have been questions, I will learn in previous year question, I will show you also. Then you will come to the right to vote. There was a specific question 3 years back, that is right to vote a constitutional right, okay, or it is a legal right, or it is a fundamental right, okay? So you have to study about right to vote. I have given the case laws also, I will talk about that. Then its various dimensions, right? From the right to vote in the recent years, right, the court have evolved various meaning from the right to vote. So right to vote means right to also know about the candidate, criminal antecedent of the candidate, and recently the judgment that relates to that political party has to give a sort of a explanation that why they are choosing a candidate with criminal background, okay? So that also has to be included, right? The recent development with respect to criminal right to vote jurisprudence has to be studied, okay? A multi-dimensional approach, right? That is what I wrote here, the various dimensions related to right to vote, okay? The PUCL and again the Kuldeep Nayyar case, okay? So that all have the various dimensions of the right to vote, okay? I have given some of the case also, you will see here, okay? So even if right to vote is not provided, you have to club it, right? It will come within the meaning of subtopic, okay? So that particular part you have to understand. Then you will come to the emergency provision. Now in emergency provision, mostly there are two things that they are asked, right? Three things, sorry. First, simply the emergency provision and their criticism specifically. that how bad the emergency provision is, how it changes the whole structure of the constitution. Okay, so it is better to have few jurist definition or few jurist criticism with respect to it. Okay, so that will suffice. Understood, right? So that particular point you have to take in mind, that while studying the emergency provision you have to study its criticism as well. Okay, especially focus on presidential, precedent rule. Okay, and the judgment related to precedent rule, how it have been used or misused, right? And what are the guideline, right? After that the misuse of this particular article have been checked. Okay, so that aspect, right, criticism aspect you have to study. There is a very famous criticism with respect to P.K. Tripathi. Okay, so you should read that P.K. Tripathi argument with respect to the criticism. Then how the historical experience have been, and there have been a very very specific question with regard to the effect of 44th amendment on it. You must be knowing that Indira Gandhi tried to change, right, 42nd amendment, multiple thing, right, and later on 44th amendment the Janata Party government amended it, and lot of things, a lot of check and balances was placed. One of them was basically emergency has to be, it has to be a written recommendation by a cabinet in order of the president to exercise his power. Okay, so that is one of the part. Okay, so after the emergency, internal emergency, in the time of Indira Gandhi, the constitution was stretched to its maximum limit. So wherever the crack appeared, that crack was supposed to be filled by the 44th amendment, right? So in that aspect you have to read 44th amendment in very very detail, right? You have to understand that what are the lacunae that came out of the original emergency provision, right? And what are the safeguard that was there with the 44th amendment, right? So you have to go into literal detail about each and every aspect of it, right? Because there have been a specific question, right, that the emergency provision after 44th amendment have been prone to less misuse comment. Okay, so you have to understand that the 44th amendment and the different safeguard that it accorded to the emergency provisions. Okay, so that particular part you have to study. Okay, so that is a very very important part. Again, I have given case law also, I will discuss again. Then the amendment of the constitution, right? Now this amendment of the constitution, right, each year there is one question, no doubt about it, right? Now this amendment of question, basically you have to study in three aspects. I have given here. Let us start. First is the amendment, simply the bare provision, right, and the difference between constituent and the amending power, right? Meaning if there is a constituent assembly and that constituent assembly is making the constitution and parliament is amending it, right? So does it mean that both power is same, right? Obviously the answer is no, because constituent assembly actually sits as a sovereign body, right? There is no one above it. Okay, it is the first trust bestowed upon few group of people that you write the constitution for myself, right? So the power of a constitution as a constituent assembly cannot be equated with the amending power of the parliament. Okay, so even if they exercise some of the portion of the constituent power, they cannot say that I am the constituent assembly. Okay, so they are at very very different footing at all. Okay, and the very plain and simple reason that they are not a sovereign body, but the constituent assembly sits as a sovereign body, right? So that is a very important difference, right? So you have to contrast and compare the difference between these two. Okay, you have to go into detail into difference between these two. Then go to the bare provision. Sometimes they ask in the bare provision, you must be knowing there are three ways to amend the constitution. By a simple majority, there is a states one, all of them, 2/3 and the majority, right? And there are certain provision which require 50% of the consent of the state, right? So that also has to be studied, 50% of the consent of the state. Understood? So that point, if you have not studied it, please go and look at these literal provisions, okay? Right? Because you have to sometimes cite those provisions itself, okay? So you have to keep that particular thing in mind. Then the second aspect of the amendment, constitutional amendment, is basically the legendary Keshavanand Bharati doctrine. Right? Now when you study Keshavanand Bharati doctrine, you should know the whole case, the whole plethora of cases in their complete format. Okay, this happened first, this happened second, right? I have written that also, right? That will help you actually. So please keep a printout of this PDF. Okay, so I'm planning to sort of club that all PDF once I complete the whole syllabus and give it to you, right? So that will also help. Okay, now when you study the Keshavanand Bharati doctrine, then there are two more things attached to it. First is the criticism part. Okay, I don't know I have written or not. Yes, criticism of this Keshavanand Bharati doctrine, that how it have sort of watered down the power of parliament to amend the constitution, right? It have made constitution so much strict that the parliament cannot introduce social changes, right? So the concept of this social tension that I talked about, constitutional tension, right? So that constitutional tensions in the beginning obviously was handled by parliament through amendment of the constitution with the varying social interest of different class of the citizens, right? But right now obviously that do not happen. Why? Because you have to satisfy the Keswanand Bharti doctrine, right? So that aspect has to be studied in the criticism part. I have also given some of the paragraph with respect to the criticism. I will talk about that later itself. Then you have to go about the multi-dimensional approach of the Keswanand Bharti doctrine. Okay, its social implication, its economic implications, right? Its legislative implications. Okay, its implication on federalism, its implication on governance, its implication on judicial review, right? So multi-dimensional approach of the Keswanand Bharti doctrine has to be studied. Okay, so you cannot simply pick point 1 2 paragraph done. No, it has to be multi-dimensional approach. Okay, and then after that, the third thing that you have to understand in Keswanand Bharti doctrine is the recent development. So you have to pinpoint the case laws. There have been multiple, almost 20-30 case laws which have further defined the Keswanand Bharti doctrine, right? So multiple things which was not there in the original judgment have been now accorded into the meaning of basic structure, right? Sometime there was a question also that what do you mean by basic structure, right? What do you mean by basic in basic structure? Okay, so the basic word, right? So you have to also understand the historical aspect of it, right? Most of you must be knowing that it comes from a German, a German professor. He came to India, right, in 70s, right? And he actually said that, okay, in German constitution they have two parts. One, the legislature cannot touch, and other part that the legislature can amend, right? So from that actually this first went to the Pakistan. In Pakistan, the Lahore High Court actually gave judgment using the word fundamental feature, right? For the first time they used fundamental feature, right? And again in our constitution, in our judgment, we use the word basic structure. Okay, basic structure, right? So this have a very historical concept attached to it. Okay, so you have to study those concept in historical aspect as well. Okay, because mentioning these things makes your answer much better, right? It makes it more interesting to read. Yes, VS is very rightly saying Professor Conard. I think Professor C Conard his name is, or I know I don't remember, but he is very right, Professor Conard. Okay, so that aspect has to be understood. Okay, so even if it is two topic, it can be subdivided into 8 subtopics. Okay, so these 8 subtopics has to be studied. Okay, even if it is not explicitly mentioned in your syllabus. Okay, and this is obviously based on the previous year paper. Okay, now let me go to some of them and try to make you understand, right, that philosophical aspect and everything, right? So first let us start with right to vote. Now this right to vote I have exactly taken from one of the article that I am writing, and hopefully in the print or it will go to wire. So this right to vote, there have been a lot of debate that which type of right it is, right? So basically it is not clear. That is the fundamental point. Okay, there are 2 judgments actually. The first judgment previously in 1952, and second judgment is Jyoti Basu, right? There they have the overall they have the court simply told that, see, we cannot decide what kind of right it is, but it is in both domain, right? What is the domain? It can be a constitutional right as well as the legal right. Okay, so initial aspect why it is only legal right? So it can be governed by the statute itself, right? So I have written here also section 61 of the People Representation Act. If you read, it specifically says right to vote. Okay, so obviously it is a statutory right? Now the question is, if it is a statutory right, does it mean that the right to vote can be controlled or can be cased by an act of parliament? Tomorrow can parliament come and say that, okay, right to vote is abolished for you? Can they say it? If it is not a constitutional right, then obviously the thing differed, and in 1982, right, Justice Reddy said that, concluded that right to vote, if not a fundamental right, is certainly a constitutional right. It is due to the constitution which mentions the right to vote that the People Representation Act shapes and couch it with limitations. Okay, it means what the court is saying, that even if it is a statutory right you are assuming, and the statute can mold that particular right, case that right, but still it is a constitutional right. Okay, so it cannot be cased in totality. Okay, so there was a sense of a hint that, okay, even the parliament they cannot abolish the right to vote, right? So if you have this particular view, then obviously the right to vote can be abolished, because it has to be couched and the case by the statute itself, right? But obviously the things differed in different case, this case, right? So that particular point, okay, thus is not very accurate to describe it as a statutory right, plain and simple, right? So that is the exact line. You cannot be saying very correct statement that it is totally a statutory right? So it is somewhere in between, right? So it is mainly a constitutional right, but the statute tries to confine it, right? Tries to case it. Okay, so that is what the statute is trying to do, nothing else. Okay, so that is one aspect that you should keep in mind with respect to right to vote. Someone emailed me also saying this, that what is the characteristics here, what is right to vote actually. Okay, so this is the correct legal position with regard to right to vote. Okay, so please keep that in mind, very very important. Then right to vote, I have told you multiple dimensions, right? So other dimensions, that see another incidental consequence of right to vote, it was in Kuldeep Nayyar case. I don't know, I have not written here. It is Kuldeep Nayyar versus Union of India. Okay, Union of India. Incidental right to vote is to right to elect, right? It was in the above case that the Supreme Court held that the right to elect is fundamental to a democracy. It is anomalously enough neither a fundamental right nor a common law right. Right, so it is also indicating it is mainly a constitutional right. Okay, then recent developments such as PUCL versus Union of India, where the court directed criminal antecedent of the candidate to be published, right? So it is one of the aspects that I told earlier as well, right? So you have to go through it, and this part actually can be used in a question of paper GS paper 2 as well. Okay, you can talk about that in GS paper 2 as well. So that remains a very important point. And recent judgment, I think in 2019 itself, that the political party have to give region when they are having a criminal candidate, giving ticket to a criminal candidate. Okay, I think Justice judgment of this, what is his name, the Chief Justice of Allahabad High Court as well. Okay, I don't remember. Okay, so that particular aspect has to be handled, right? Has to be studied, very very important. Okay, Justice Chandrachud. Okay, then come to the emergency part. Right, now I have given here some of the philosophical basis of emergency part. Right, now do not raise your hand right now. Let me finish with my whole this lecture, right? Then I will take your questions. Okay, now nature of emergency. Right, now if you look at the nature of emergency, right, the Ambedkar line has to be written if there is a criticism regarding it. How? The Indian Federation was unique in as much as the times of emergency it could convert itself entirely into a unitary state. Okay, totally unitary. Except from judiciary, the executive and the legislature will become unitary in nature, right? And when the emergency provision, the whole provision of emergency was challenged that it is unconstitutional, against the basic structure of democracy, right? Now the court held in this Ghulam Sarwar versus Union of India that no, it is an important provision which has to be used randomly, seldomly. Okay, sometimes it has to be used. It should not be used all the time. Okay, but you cannot say the whole provision is unconstitutional. But obviously I am also of opinion that in a democracy like ours, right, this emergency provision should not exist, right? But after 44th amendment, chance of misuse is very bad, and obviously there is a historical aspect as well, right? So even if a new prime minister tries to somehow amend the constitution or misuse the emergency provision, the history will serve as a lesson. So I don't think it will be misused, but still. See, similarly from V.N. Shukla, one paragraph I have taken, that is a very very good paragraph with respect to the emergency provision. Okay, so you please keep a printout of this and you can write that directly in exam. See, the Constitution of India is unique in the respect of it contains a complete scheme for a speedy readjustment of peacetime governmental machinery in the moment of national peril. How beautiful line it is written, right? So this line can be directly used in exam. Okay, so that particular point has to be kept in mind. Okay, similarly, but the provision must be studied in the light of India's past history. India had her glorious days whenever the central power grew weak. Now that is a very interesting observation, right? Like in GS paper 2, there was a question that I gave last year in the mains test series, that India have achieved its maximum growth or best governance only when we have a coalition government at the center. Okay, right? So that indicates India is built for federalistic form of government, right? So whenever we have a centralizing or unitary tendencies, India's growth, economic growth, and anything was not better, right? It has not been better, right? So that is what this is also indicating, right? So the glorious days was only when the central was weak. Okay, states were strong. Okay, so that is something very interesting observation. Okay, events may take place threatening to the very existence of the state, and if there are no safeguard against such eventuality, the state together with all its that is desired to remain basic and immutable will be swept away. Okay, it means it is criticizing as well, and it is somehow supporting the argument, right? So this is the best finishing line when you have to criticize the emergency provision. Okay, so pinpointed, रट्टा मार लीजिए इसको, जैसे ही कोई क्वेश्चन आए इमरजेंसी में, you have to write this line. Okay, it is a very very perfect line to be written. Understood everyone? Okay, so yes, so please keep that in mind. Now let us come to the unique Kesvanand Bharati doctrine, very unique actually. Now obviously I'm not going into nitty gritty and detail, but I will do mention important cases, right, that have happened, right. So first was the Sankri Prasad, right, in which the land amendment Bihar Land Reform Act was there, right, and it was upheld by the I mean that law was not upheld when quashed by the Patna High Court, right, because obviously Rameswar Prasad Singh, he was also Jamindar, right, and most of the judges of the Patna High Court who actually made that particular law constitutionally invalid, they were also Jamindar, right. So that Bihar Land Reform Act, right. So obviously their own property would have been seized because of that law, right. But obviously that led to a political movement, constitutional tension actually, right. And the people wanted to have more and more land reform, and that led to the amendment of 31A-B. Okay, and the introduction of the ninth schedule. Now that is a very interesting thing, because 90% of the member of the parliament at that time were the same whom wrote the constitution. Okay, and the parliament was a provisional parliament that amended it, right, because the election took place around 1952 onwards. Okay, so obviously it was a temporary provisional parliament that actually made the amendment, right. So this question also arose, that how can a provisional parliament amend the constitution itself. Okay, but obviously court at that time, very socialistic type, and said that no, the question of challenging the constitutional amendment do not arise. Why? Because that do not come within the meaning of law given in Article 30. Okay, so the court said that no, I don't want to see, because at that time most of the judges had the this colonial backgrounds. Okay, and they were ready, and independence came, right. So they were filled up with nationalistic feeling, and they had lot of trust in the parliament, right. So they decided not to go into that okay, whatever parliament is doing, that is okay. Okay, so that kind of situation was prevailing at that time. Okay, then obviously Sajjan Singh, when the people started to misuse it, right, then it came, and it was held that the word amendment of the constitution means amendment of all the provisions. Okay, it means that even if you amend any provision, that can come within the meaning of Article 13 law, meaning the meaning of law within Article 13. Okay, right, and that led to another challenge of the same judgment, because parliament was furious that how can they can doubt us, that I cannot amend the constitution, right, I am supposed of sovereign, right, those sort of stuff, right. But obviously Golaknath again confirmed Sajjan Singh, overruled Sankri Prasad again, right. Then came as a response of this Golaknath, this amendment came, 24th amendment. Two things they did: one, in 360 they wrote that it cannot be challenged, and Article 13 they clause 5 they wrote that any law which is made under Article 368 is not a law within the meaning of this article, that is Article 13, right. So they created sort of two safety net, amending Article 368 saying that parliament can amend, it is beyond the power of Supreme Court. Article 13, the meaning of law do not include the constitutional amendment of this particular constitution. Okay, but obviously that was finally challenged in Kesavanand Bharati doctrine, you must be aware, right, as a law student, and ultimately led to a very, very famous judgment of Kesavanand Bharati doctrine. Now I'm not going into nitty gritty, but remember, do read important lines of different judges, right. Okay, important lines of different judges, and you have to side, okay, this Justice Sehlat said this, Justice Sen said this, Justice Khanna said this, right. So that line has to be remembered, or at least you have to quote verbatim in your exam. Okay, so please read important lines with respect to that. Okay, then we will come to the criticism of the doctrine. Obviously a lot of criticism have been there in the doctrine, right, and one of the most important criticism is it is very vague and uncertain. Okay, it do not lay down. In fact, when this 13 judge bench was there, and thereafter a 15 judge bench was organized, right, and the government of India wanted it to be challenged, right. So very the Attorney General at the time appeared before the court, and the one thing he said that okay, I do not understand this doctrine, what this doctrine is. Okay, when the judge itself became the Chief Justice after bypassing two, right, he himself said that I do not understand this doctrine, right. Then very cleverly Nani Palkiwala replied that if my lordship could not decipher its own judgment, then the whole thing will go to peril, right. So that was a very interesting argument, right. You must have read about it. Very interesting argument, and ultimately after 3 days of argument the bench was dissolved. Okay, so it was a very interesting in fact in the Supreme Court, right. I have read in the books, right. Okay, so the criticism, the one important criticism that you can see, right. Second important criticism is that it is not nicely dried up, right, how to apply it, because all the law has to be based on multiple niceties of exactly pinpointing the law position or the scope of that particular application, right? Application of that particular law. That okay, this is the situation, this is how the law will apply. This do not provide that. Okay, very vague. Okay, now for that, I have given one argument here. Chief Justice said that because something cannot be dried and nicely weighed and measured and therefore does not exist is fallacious. Okay, so there is a beautiful line that you can write as a counter argument, that in a law field, right, if you are from the law student background, I mean if you are from the law background or law student, you must be knowing that most of the doctrine that is laid down in law is not very, you can say very precise, right? They are sometimes vague, right? It is up to the court to basically strengthen its vagueness, right? In fact, it is a good thing that the doctrine are vague, so that it can be adjusted according to the situation, or it can somehow adjust the whole the development of that law, right? It gives a scope to development of that law. So if it will become rigid, it will be very, very bad, right? The same thing happened in Article 14 as well. That doctrine related to this the purpose of the law must have a reasonable nexus with the intelligible differentia. That is a very strict doctrine. That is why different doctrine of arbitrariness, which is again very unprecise doctrine, right? Or the doctrine of positive discrimination, that all came because of this rigid doctrine of Article 14, right? So the same thing applies here, right? So even if the doctrine is not rigid, that doesn't mean it's a bad thing. What is that quote is again saying, right? That if it cannot be weighed, measured or nicely dried up, ठीक है, सुखा के बढ़िया उसको अगर आप नहीं कर सकते हैं, it doesn't mean that the doctrine do not exist. Okay, so that is a very interesting thing. If the historical background, preamble, entire scheme of the constitution and the relevant provision is including this are kept in mind, there can be no difficulty in determining what are the basic element and the basic structure of the constitution. Okay, the doctrine of basic structure will act as a safety valve against the arbitrary use of the amending power. Okay, so this is a perfect line to be written in any type of question related to criticism or the philosophical aspect of the basic structure doctrine. Okay, so again keep that in mind. Now, I have told you in the beginning itself that not only you have to study the basic structure, but also you have to study the subsequent development after the judgment. Okay. Now, there are two important development actually. The first development with respect to the keeping of law in the 9th schedule, right? That is your IR Italo case, right? And whether the judicial review is a part of basic structure or not, right? So there are multiple cases, right? I have not written all the cases, but you have to read all the cases related to it, okay? But I have written this IR Coelho, right? So this IR Coelho is a very interesting case, right? It actually said the current position, there was a concept of doctrine of perspective ruling that came into picture. See, it actually said that, see, after a particular date of the judgment of the Kesavanand Bharati, if any law is given under the 9th schedule, this is protected, it cannot be challenged. But the process of putting that law can be challenged, right? It can be challenged that the schedule 9 which was added to the constitution for a particular purpose, right? So by keeping any law in that particular schedule 9 is not serving that purpose, so on that ground it can be challenged. Okay, now once the law passed this muster that okay, this is a law, yeah, this is something which can be put into article schedule 9, then once it is put, it is beyond the judicial scrutiny, right? But the putting of it can be challenged, right? So that is the primary ratio of the IR Coelho, right? And it was criticized because why you are only saying that after this judgment, why not before this? Okay, so the court said that it will be like of opening a can of worms, right? So how much lot of cases will come and lot of problem will get created, tensions will be there, so let us skip that, right? So very unique thing happened, because that doesn't happen when a constitutional amendment is declared void. It is a ab initio, right? Most of the cases, right? So that is something unique that happened in IR Coelho. Okay, so please keep that in mind. Now let us look at some of the previous year questions. See, the doctrine of basic structure has established judicial supremacy in the area of the constitutional amendment, right? So it has sort of cemented the judicial review as part and parcel of the constitutional mechanism, or constitutional philosophy, in fact, constitutionalism, in fact, constitutionalism also, right? So you have to study, I have told you, multiple dimensional approach, right? So it was a very recent question, I think it was in 2017 it was asked. Is the power of amendment implicit in the Constitution of India, and is it wide enough to replace the present constitution by a new one without the need of revolution or referendum? Discussed by making reference to the Kesavanand Bharati doctrine. Okay, so you have to start with the whole case law and ultimately reaching that okay, the amending power of the parliament cannot be equated with the constituent power of the constituent assembly, right? And you have to pinpoint the difference citing from the judgments of case 1 and part 2. Okay, again a philosophical type of question. इसमें you don't go through the whole case law in detail, just mention that in passing line. Okay, examining the amending power of constitution, whether it can be termed as limited amending power. Obviously the answer is yes, right? So again you have to write that why this particular citing the historical aspect, why this particular philosophy or approach was adopted by the Supreme Court, because they saw the misuse of the constitutional amendment. Okay, then the framer of constitution felt that in emergency the center should have overriding control and directed all aspects of administration legislature throughout the country. Elucidate. Okay, again the philosophical aspect of the emergency provision, the line that I have paragraph that I have given earlier, so that will be sufficient for this answer actually. Then on what ground, duration and consequence of the proclamation issued by the President of India pertaining to failure of constitutional machinery in a state is the self-proclamation justifiable? Obviously the answer is it is justifiable but subject to judicial review. Okay, subject to judicial review. Okay, so again a philosophical or sort of criticism of half of the answer is the criticism, half you have to simply write the literal provision, right? And then you have to write that the failure of constitutional machinery is a very vague word, and it have been interpreted by the courts in multiple judgments. Okay, so you have to write those things down. Okay, then what are the restrictions that have been imposed by the constitutional amendment? See, 44 to the check the misuse of the proclamation of emergency. I have told you there was a question with respect to that. Okay, so you have to go into nitty-gritty, that after the emergency was imposed before 44th amendment, what are the cracks that appeared, okay, and how 44th amendment tried to fill up those cracks or those voids. Okay, so that is how we will approach these 6 questions in detail. Okay, now this is the 6th question itself. I will give you to actually try to write it down, because it will cover a lot of aspects. Okay, understood everyone? Yes. Now let me discuss some of the questions. Okay, let me discuss some of the questions, then I will take your questions. Okay, yes. Yes, so let us start with one of the questions. I have taken 4 questions today. The question was related to explain the doctrine of pleasure incorporated in the Indian Constitution in respect of civil servants. Okay, highlight the safeguard for protection of civil. Very simple, fair and simple question, right? So we have to first explain the doctrine of pleasure. Okay, you have talked about this. Okay, but we could have started with doctrine of pleasure itself. Okay, but okay, ठीक है. Good. Yes. Common law principle. Okay. Good. This has to be written. Defense personnel. Okay. Have you written the purpose of the pleasure? Why this pleasure? Yes. You have not written, right? So write why. Acha, you have written here. Yes, correct. Good. Constitutional limitations. Your safeguards will be much better word, right? Safeguards. Yeah, this specific. Okay. No, this is not the constitutional limitation. This is actually the exceptions, that these shall not be dealt by doctrine of pleasure. Okay, that is not the limitation, exceptions actually. This is the constitutional safeguard. Yes. Okay. Doctrine of pleasure. Constitutional safeguard. Okay. Restriction. Good. Yes, you have written Khemchand. Yes, very important case. Price. Whoever he is improving a lot. I think last time the answer was not very correct. Formality given, yes, that is also correct. Yes. Now the content is good and the structuring also is good. Okay, both is good in this answer. Okay. Achha, this is Gagan. Okay. You have improved. The first question I don't think you have written nicely. Now who is this guy? Whose answer is this? He or she is not there, I suppose. Okay. Explain the doctrine of pleasure and okay, same question. Okay, Sivangi, yes. The civil servant is in the decimal part of governance of the country. Okay. Give one more gap. Do not write more than 2-3 lines as a paragraph, right? A maximum 4 lines, right? So this long paragraph will not do. Okay. Make it shorter or split it. Okay. Split it. Introduction is very correct actually. Incorporated revision. Okay. Not British law. You can simply mention as a common law doctrine and the public policy as a philosophy behind it, right? So that will suffice. Okay, so यहाँ पे आप इसको इम्प्रूव कीजिए, ठीक है, इम्प्रूव इट. दिस होल पैराग्राफ कैन बी रीमोल्डेड. Constitutional limitations, okay. This, this point actually we're taking, make it above, okay, and then clearly talk about the limitations. Now what is this? This is the presentation I am talking about. Will you write answer like this? No, it has to be proper, right? Presentation means a small thing. It should also look nice, okay? So try to improve that. Very important case. Good. No dismissal, yes. See how badly it is written. भाई यहाँ पे चौथाई छोड़ते हैं ऐसे, फिर लिखते हैं आंसर, ठीक है, थोड़ा सा चीज़ें ठीक कीजिए. This content is good, but little bit presentation is bad, okay? Focus on presentation. Content is okay because question itself was very simple. Now who is this S. Upadhyay? Is he here? Okay. S.U. S. Upadhyay. Okay. Explain the doctrine of pleasure and okay. See again. Do you think Mr. Upadhyay, the teacher is going to read this paragraph, the small things and no space between the lines? So that is a very bad presentation, right? इसमें अगर आप यहाँ पर थोड़ा सा नीचे से लिखना शुरू करते हैं यहाँ से, तो क्या दिक्कत हो जाती है, ठीक है. मैं बार बार कह रहा हूँ, अगर आप मेहनत करने को देंगे, जो आपका एग्जामिनर है वो आपके नंबर काट लेगा, मेहनत नहीं करेगा वो. समझ में आ रही बात की, राइट? सो मेक एवरीथिंग ईजी फॉर हिम, कि हाँ भाई ये लो, एकदम सब कुछ क्लियरली है, चेक कर लो, ठीक है. मेहनत उससे मत करवाइए, ठीक है, मेहनत आपको करनी है, ओके. वो ऐसे पिन पॉइंट नहीं करके चेक करेगा. प्लीज़ कीप दैट इन माइंड. ठीक है. You could have mentioned British common law heritage, okay. Safeguards, see, safeguard अच्छा. फिर इसको बना कीजिए, ठीक है ना. थोड़ा इसके बाद चेंज होना चाहिए पैराग्राफ. 3 लाइन से ज़्यादा आपका ये पढ़ना में बड़ी दिक्कत हो रही है. ओके, गुड गुड. ये सब 309, हाँ 39, ठीक है, ठीक. कंक्लूजन, प्रेजेंट सिनारियो लिखिए, ज़्यादा सही है, ठीक है ना. ठीक है. कंक्लूजन इज ओके, राइट. लेकिन वही है कि स्ट्रक्चरिंग ठीक कीजिए, ठीक है ना. स्ट्रक्चरिंग कर रहे हैं, सॉरी, प्रेजेंटेशन. कंटेंट सही है, स्ट्रक्चरिंग भी ठीक है, प्रेजेंटेशन पे थोड़ा इंप्रूवमेंट लाइए, ठीक है, वेरी इंपॉर्टेंट. चलिए अगले में आते हैं. इस किसका कॉपी है ये? हुज कॉपी इज दिस? नो वन इज हियर आई सपोज. ओके, नो प्रॉब्लम. Explain the doctrine of pleasure. Okay, Divya. Okay, you are one of the student of writing practice also, Divya, right? I remember you. Highlight the safeguard. ठीक है. ठीक है, बहुत ज़्यादा अंडरलाइन करने की जरूरत नहीं है, ओके. डू नॉट अंडरलाइन एवरीथिंग, ओके. एक्सरसाइज ऑफ प्लेजर, ये प्लेजर हाउ एक्सरसाइज, ठीक है, इट इज ओके. सेफगार्ड्स, नो रिमूवल, रीजनेबल अपॉर्चुनिटी. देख कितना अच्छा स्ट्रक्चरिंग लग रहा है. ये लिख लिया, ये लिख लिया, ठीक है. एग्जामिनर को दिमाग ही नहीं लगाना है, ठीक ना. सीधे सीधे वो समझ जाएगा कि कहाँ पे क्या लिखा है. हाउ ब्यूटीफुली. सुखराम सिंह, स्टेट ऑफ पंजाब, ओके. एक्सेप्शंस पूछा नहीं गया था वैसे, ठीक है, मेंशन कर दिया, लेकिन ये पूछा नहीं गया था. ये लिखिए, ज़्यादा इंपॉर्टेंट है ना. ठीक है, लेकिन ये मतलब स्पेसिफिक पॉइंट ना देके जो ऊपर का कॉन्स्टिट्यूशनल सेफगार्ड है उसके एक्सेप्शन में सीधे लिखते तो चलता. ठीक है, ज़्यादा ही इंक्वायरी पे आपने ज़्यादा ही फोकस कर दिया है, ठीक है ना. थोड़ा सा इसमें कंटेंट और इम्प्रूव करना पड़ेगा. 2-3 चीज़ें आपने यहाँ स्किप की है, ठीक है ना. वही है, पढ़ाई की कमी लगती है सीधे सीधे, राइट. पढ़ाई होने पे जो ना सारी इन्फॉर्मेशन पास में रहती है, ठीक है. चलिए, तो ये मैं और आज का क्वेश्चन में बता दूं, जो लोग लेट आए हैं, क्वेश्चन नंबर 6 आपको करना है, ठीक है ना. यू हैव टू डू क्वेश्चन नंबर 6 फॉर टुमारो. अच्छा, और इस वीक मैं थर्सडे तक ही क्लास लूँगा, मतलब कल तक ही क्लास लूँगा. उसके बाद मंडे लूँगा. मैं मंडे टू फ्राइडे लेता हूँ, राइट. बट दिस फ्राइडे आई हैव दिस लॉ ऑप्शनल बैच स्टार्टिंग, राइट. तो उन लोग को थोड़ा सा देखना है, राइट. तो मैं मंडे से क्लास लूँगा, ठीक है ना. कल लूँगा, उसके बाद मंडे लूँगा, फ्राइडे नहीं लूँगा, ओके. सो कीप दैट इन माइंड प्लीज. Okay, चलिए तो पूछिए. If you have any question, you can ask me, or otherwise we will end this discussion. Yes, go ahead. Raise your hand, sir, and will unmute you, and you can ask the questions. Yes, thank you. So I don't think today anyone have any question. Okay, one person. Yes, Asmita, go ahead.
Firstly, good afternoon, sir.
Good afternoon. Good afternoon.
Sir, could you please share the all questions once again so that I could take a screenshot?
No, this whole I will give you in the PDF file in the Telegram, not to worry.
Okay, fine. Thank you, sir. Thank you very much.
Yes, everyone. Then I think question is not there, right? So let us end this discussion today, right? And tomorrow we will start with the administrative law, right? So two topic of administrative law I will discuss. Okay, that is a very huge topic, administrative law, right? So I will try to discuss each and every topic in detail. Okay. Achha, one more question is there. Yes, VRM, go ahead.
Good afternoon, sir.
Good afternoon.
So my question is, when the question specifically asks for the provisions of the Constitution to enumerate, is it good to give it a philosophical touch or not?
No, if they ask a very, the question simply says what are the provision of related to this in the Constitution. That's it.
Yes, sir. Like the Article 311 question.
Okay. No, in that aspect, see, whenever there is a constitutional provision questions, right, bare constitutional provision, write down, and then also write important case laws related to the key word in those articles. That will suffice. Okay?
Okay, sir.
Okay.
So, yes, sir. Okay, sir.
Okay. Yes, Mr. John Wick, go ahead.
Good afternoon, sir.
Yes, good afternoon.
Sir, I have a question that, like in this question, we were dealing with Article 311. So I want to ask that, sir, in a judgment, Minerva Mill case, it was decided that everything in India is under the ambit or purview of judicial review. So can we?
No, that was not decided. Who told you that was decided?
It says that article, the concept of judicial review would be a dead letter if it is not used effectively.
Yes,
so
that is what it is. But it do not imply that everything will come under judicial review.
Sir, so my question is that whether in order to give a philosophical touch to a question, can we relate such topic to Article 311? So can we relate our judicial review with the decision of Minerva Will?
311, no. That will be a very huge imagination, a stretch of imagination. So I will tell you that whenever there is a question on 311, you stick to civil servants only, right? Do not go to Minerva Will in that case.
Okay.
Yes, Mr. Dinesh, go ahead.
Sir, good afternoon, sir.
Good afternoon.
My question is that, when emergency is declared in the nation, it states that the fundamental rights are suspended, but their enforcement is not suspended. Actually,
agreed.
What is the exact meaning of it?
See, the exact meaning of it is a very good question. Obviously, I'm not taking a whole law optional class. That is why I did not explain to you. But there is a very interesting question. See, what happens? What this particular constitution says that, see, whenever there is emergency provision, only the right to move court is suspended, just because of the reason that we don't want to put additional burden on executive because there is an emergency. Now, once the emergency is subsided or it is ceased to exist, right, then obviously the same case can be reheard again in the court, saying that okay, you enforce this fundamental right. Okay, so that is only a temporary sort of eclipse over the going to the court. That's it, nothing else. Right, so do not extinguish your right at all. It do not extinguish the wrong done to you, right? So everything can be, the executive can be held accountable, but after the emergency is over. That is actually the point.
Okay, thanks.
Okay. One by one, Asmita, please ask, one question only, right? Do not ask multiple questions at the same time. You remember it. Yes, go ahead. No problem. Ask me.
Sir, so it's been mentioned like there is suspension of Article 19 during the proclamation of national emergency.
Not suspension. Suspension of the moving to the court for the enforcement of Article 19.
Okay. So if in that point of time the contravention is there of any of the rights of Article 19 or 21, then do we have right to approach court of law once
yes,
of these emergency period is over?
1921, depending upon the type of emergency, comes under the exception, right? Suppose, if I am talking Article 23 is violated, that is not under the exception, but still you can go. Suppose your 23 was violated today and emergency is in operation, you cannot go. wrong have been committed to you, right? But after the emergency ceased to exist, you can still go for the enforcement of your remedy. That is not a problem at all.
Okay, thank you, sir.
Okay. Okay, so that will be all for today. Let us meet tomorrow with the administrative law syllabus explanation. Okay, thank you everyone.